Good afternoon, ladies and gentlemen. Welcome to Dr. Olu Asekun podcast. Today is another beautiful Wednesday. Thank you for joining us. Today is one of those days that we have a lot to discuss. Unfortunately, we don't have time. We don't have time because I have to be in court by 1 o'clock, which is now in about 59 minutes. I have to be in court, and of course, I have to leave before the time. Please help me set the reminder. So, as I said, today we have a lot to discuss. There's a lot of new things that I wanted to discuss. I'm not even sure if we'll be able to finish it today, because if I have to finish, we may not be able to answer any question. Before I proceed, as a reminder, please invite your friends, colleagues at work, family, friends, and join us every Wednesday at 12 p.m. Central Standard Time. That is currently 6 p.m. Nigerian time. Currently 1 p.m. Eastern, and currently 10 a.m. Pacific, and 11 a.m. Mountain Time. Okay. As a reminder, I wanted to remind our followers that today is August 20th, 2025, and today the visa bond is effective today for nationals of Malawi and Zambia. Other countries will be added later, but right now it's taking effect today only for nationals of Malawi and Zambia. For other countries, there will be 15 days notice before the effective date. As of today, other countries have not been announced. So I've received questions from Nigerians who are asking me whether Nigeria is subject to visa bond. As of today, no. They have not been added to the visa bond countries as of today. So, going forward, as I said, there's a lot to discuss today. This is because USCIS just released a new naturalization policy. Naturalization is citizenship. They just released a new policy regarding citizenship. Like I said, there's a lot to go over today, but I'm going to discuss the citizenship aspect because that's the one that I know that will impact a lot of people who are currently permanent residents, but they are not yet citizens. So they rolled a lot of new policies out. As I said, it's a new policy, so I don't even have everything in my head right now. So that's why I had to come up here with a note. So the first thing regarding the naturalization, and this new policy is effective August 15. August 15, that was Friday. That was last Friday. So it's already effective. So even if you have a pending application for citizenship, you are going to be impacted by what I'm about to say. Under the new policy, which is effective August 15, 2025, the policy hopes to restore what immigration termed rigorous, holistic, and comprehensive good moral character evaluation standard. I want to repeat that. The policy hopes to restore what USCIS termed rigorous, holistic, comprehensive, good moral character evaluation standard. So, under the new policy, immigration is going to adopt what they are calling totality of circumstances approach for good moral character. I've always known and advised my client that when it comes to good moral character, for the purpose of citizenship, it's a blank check for USCIS. But now, the blank check is even made wider. So, totality of circumstances approach in determining good moral character. So, what does that mean? What that means is that in evaluating good moral character for the purpose of citizenship, going forward, effective August 15, USCIS is now going to be considering both absence of disqualifying act and the presence of positive conduct and character. So before now, you just want to be sure that you don't have criminal record, you don't have any drug conviction, you don't have anything. But now, under this new policy, they are saying that is not enough. They are going to now look at your contribution to the society. So, under the new approach, it will reflect a genuine positive assessment of who the applicant is and how they have lived within their community. So, in order for people to understand what I'm trying to explain, I've decided to break it down in a few ways that we will understand it. So, under the new policy, one, there will be great emphasis on positive attitude and contribution to the society in determining good moral character. Some of the positive factors that immigration is going to look at, some of the information they provided to us, they will be looking at, number one, sustained community involvement and contribution in the United States. It is possible for somebody to have lived in the U.S. for be a permanent resident for 5 years, apply for citizenship, you don't have criminal record, you don't have anything. But now immigration is going to ask you, what have you contributed positively to your society? So you now have to meet sustained community involvement and contributions in the United States. Two, factors that can help you: family caregiving, responsibility towards children, and ties in the United States. In other words, volunteering service is going to now be useful. Volunteering service is now going to be useful. Additional thing that they are going to be looking at in determining positive attitude or attribute is educational attainment. I know that for Nigerians who are watching me, that should not be an issue. I know that a lot of Nigerians here, even once you get here, you go to school, you educate yourself. So Nigerians will probably have edge when it comes to that. But again, they are going to be considering that in determining good moral character for citizenship purpose, educational attainment. The next one is a stable and lawful employment history and achievement. So they are going to be looking at your employment history. What they are trying to do here is that for those who are not working, those who are relying on unemployment, those who are relying on SSI, those who are self-employed but they are not reporting their income, if you are not yet a citizen, it may be an issue going forward under this new policy. The next thing they will be considering too is length of lawful residence in the United States. Of course, we already know that for you to be eligible for citizenship, depending on your category, you have to be a permanent resident for 5 years. So length of lawful residence in the United States will also be something to consider in determining whether you are a person of good moral character. And another one is compliance with tax obligations and financial responsibility in the United States. Before now, I've always known that if you owe IRS tax, it can be an issue during citizenship. But now, they are now giving USCIS the authority to actually now look into your tax filings, to now look into your financial obligation, your financial responsibility. That is going to be part of determination now for citizenship purpose. So what that means is that for those who apply for citizenship now, it is possible that USCIS is going to start asking for tax return. They're going to be asking for tax return now. So all these things are part of what they will be considering in determining whether an applicant is a person of good moral character for the purpose of citizenship. So that is positive attribute. The next one, under the new policy, there will be greater scrutiny of disqualifying behavior and actions. Of course, we already know that criminal conviction will be an issue, but under this new policy, there will be greater scrutiny of disqualifying behavior and action. So what that means is that USCIS is going to focus greater attention on whether an applicant has engaged in any behavior or act that disqualifies the applicant from being found to be a person of good moral character. Now, examples of disqualifying behavior or action that USCIS provided to us under this new policy. One, permanent bar to good moral character. That is those people who have committed what we term aggravated felony offenses, maybe offenses such as murder, crimes of violence, persecution, genocide, torture, severe violation of religious freedom. Those ones are going to be a permanent bar to citizenship. The next one is conditional bar to good moral character. Examples given to us by USCIS of conditional bar to good moral character will be controlled substance violations, 2 or more convictions for driving under the influence, false claim to U.S. citizenship, unlawful voter registration, unlawful voting, overdue child support or other family obligations, overpayment of benefits such as SSI, Social Security. What does the I mean? SSI.
Social Security.
Well, I find out because I just wrote they wrote it as SSI. They didn't even.
Supplemental Security Income.
Okay. Oh, supplemental. That's not Social Security then. Okay, supplement. Oh. That is those who are applying for full stamp.
Yeah.
Full stamp, housing, and all of that. Yes. Supplemental security income. Yes, those who are applying for full stamp, those who are applying for housing, and all of that. So if they found out that maybe you did not provide your full income in order to be eligible, or maybe you are married, but because you want to be eligible for full stamp, you stated that you are not married. All these things are now going to be a bar to citizenship. So the next one, before I go into the next one, after supplemental security income, then if you owe tax, either state tax or federal tax, it will also be an issue for the purpose of citizenship. If you owe child support, it will also be an issue for citizenship going forward. The next one, any other acts that are contrary to the average behavior of citizens in the jurisdiction where the applicant reside. Again, this new policy is full of blank checks. I mean, what constitutes average behavior? What A may see as the right behavior, B may see it as not right. Again, a lot is going to depend on the discretionary decisions of USCIS officers, because these are blank checks that is going to be really, really difficult to overcome if for any reason they believe that the applicant does not have good moral character, because this is just too too wide. It's just too wide. It says any other act that are contrary to the average behavior of citizens in the jurisdiction where the applicant reside. Then this could be actions that, while technically lawful, may be inconsistent with civic responsibility within the community that the applicant reside. Example, habitual drinking, habitual traffic infractions, harassment, or aggressive solicitation. This one caught my attention. For those who are in marketing, you have to be careful now. I mean, solicitation generally is not a crime, but if immigration determines that your solicitation is aggressive, it may be an issue if you are not yet a citizen under this new policy. I mean, like I said, this policy is full of what I consider blank checks, a lot and lot of blank checks. I mean, aggressive marketing, aggressive solicitation. The next one, in assessing acts that are unlawful and contrary to the average behavior of citizens of the community in which the applicant reside, USCIS will review all available documentations and questions the applicant seeking naturalization. They will question the applicant seeking naturalization regarding the specific circumstances of their action to determine if a particular situation or act should bar an alien from naturalization. So what I want to point out here is that even information on social media can now lead to citizenship. Even text message exchanges. I mean, like I said, there's a lot of discretionary issue here based on this new policy. Now, according to the new policy, there will still be room for rehabilitation and reformation. So what that means is that USCIS will also focus greater attention on ensuring that applicants who have engaged in wrongdoing are properly rehabilitated and reformed. Consistent with the totality of circumstances approach, evidence of genuine rehabilitation may support a finding of good moral character. This includes, but is not limited to, rectifying overdue child support payment or other family obligations. So in other words, if you owe child support and your application for naturalization is denied, if you go back and pay all the overdue child support and maybe give yourself some time and then reapply. So what this policy is saying that they will look at rehabilitation if you have been rehabilitated. Another example is compliance with probation or other conditions imposed by a court. If a certain act disqualifies you, immigration will give you time to rehabilitate yourself, to comply, and then what that simply means is that it may not be a lifetime ban. After some time, if you show evidence that whatever disqualifying you, that thing has been cured, and you waited some time, you may show evidence of rehabilitation. Another example is a community testimony from credible sources attesting to applicants' ongoing good moral character. Again, my recommendation, if you are not yet a U.S. citizen, whether you have your application pending or you are planning to apply in the future, this may be the best time to volunteer, participate, get involved in what they are doing in your city. I mean, a lot of cities have volunteering program. Go there, participate. If you are a religious person, make sure you get involved in your church. Get involved in activities in your church. At the end of the day, it is the leaders within the society, within your communities that will give you letters that will give you recommendations. Even during voting, go to congressman's office, go and volunteer, go and be a volunteer. Whenever they are doing a community outreach program, go there and participate, volunteer, get involved. So generally what this new policy is trying to achieve is that they want people to belong to the community, to participate in the community. They don't want people who will segregate themselves and then at the end of the day just come out after 5 years and apply to be a citizen. The bottom line of this policy is that if you want to live here, do what we do here. If you want to live here, if you want to be a citizen of this country, you have to participate in what we are doing here. That is the bottom line from what I see from this one. Another example, still talking about rehabilitation. Reformation or mentoring those with similar past. So maybe if you are falling short of one of these disqualifications, and if you are able to restitute, maybe you didn't pay tax before, now you have now paid your outstanding tax, or maybe you didn't pay child support before, now you have paid your child support. What they are saying is that if you volunteer to mentor other people who are coming behind you, oh, you know what, don't make the same mistake that I made. Maybe you do community service, do mentoring program. That will also count for you as evidence of rehabilitation. Another example of rehabilitation, full repayment or overpayment, full repayment of overpayment of benefits such as SSI. Again, if you apply for benefit that you didn't qualify for under this new policy, you better go and start making restitution. If you have applied for housing, claiming that you didn't have income when you did, maybe you hide your income, maybe you got your green card as a spouse of a US citizen, and you are applying for full stamp, you claim that you are single when in fact you are married. All those things, it is time to restitute. Just go back to wherever the application was made, go and fix it. And if they determine that you have been paid, the payment that you are not eligible for has been made to you, just restitute, refund their money, refund all the government money that you have collected when you are not eligible for it. So that is part of what they are saying, that those will be considered as part of restitution. Another one is another example of restitution would be full payment of overdue taxes. I mean, even before this new policy, I've seen citizenship that was denied because somebody was owing IRS tax, and the IRS, this person signed a payment plan agreement with IRS, and the person did not default. He was paying as agreed, but at that time, USCIS still denied the application for citizenship on the ground that he only paid the tax because he was caught, because IRS audited him, and that was the reason he agreed to pay the tax. So what this restitution is saying is that if you owe IRS taxes, or if you file taxes and you claim the benefit that you are not eligible for, you may need to start restituting now, so that if immigration found out and they want to deny your citizenship on that basis, you can claim that you have made restitution. So that is another example. Now, this approach will empower USCIS officers to review the complete history of applicants seeking naturalization. So naturalization is no longer going to be as easy as it used to be. Now they want to grant naturalization to only people who are part of the society, people who participate in the community where they live. In addition to not having criminal record, they are saying that Criminal record, yes, those are negative acts that can disqualify you. But they are also saying that not having positive action can also deny you citizenship. Not participating within your community can deny you citizenship. Not getting involved can deny you citizenship. Even lack of sufficient education can deny you citizenship. So, like I said, there's a lot of blank checks here, but all the examples I gave today are the specific examples given by USCIS. I've not added my own example. I've not taken out of their own example. These are the specific examples that they gave. I see that it's already 12:27. I don't know whether I should go into the next topic because, like I said, there's a lot of information today, but I also have to be in court at 1 o'clock. So do we continue next week and answer some questions?
Let me see what the.
So how many questions do we have so far?
There's a lot.
That's a lot. Okay, let's go into question. Next week, we are going to be talking of I-130 petition that can be filed at the U.S. Embassy. That is the next update that I was going to give. But as I said, I wish today is one of those days that I have 2 hours. I will have been able to exhaust all these things. But we'll talk about that next week. Hopefully, there will be no court case next week, Wednesday. But the top, I will start from U.S. citizen filing a petition for their immediate family at the U.S. embassies all around the world. They just started that new policy again. That is also effective as of August of 2025.
You're not here
Next week, Wednesday.
Yeah, you're not here.
Oh, well, let's see. I mean, what can we do? Let's try to answer some questions because if I go on into that one now, that one too is very extensive. We may finish the entire 30 minutes, 1 hour without answering any question. Let's answer some questions. We'll continue. We add the update to the next one. So, good day, sir. God richly bless you and your team. Amen. Please, what's the normal time frame for I-751 after interview? Well, I-751, can you please check the processing time for I-751? I mean, I know that I-751 takes a lot of time because even right now, I think
48 months?
the extension is given for 48 months.
Yeah.
So 48 months, that's 4 years. So it's about 4 years. But you don't necessarily have to wait for the 751 to be approved. If you are eligible for citizenship, you can go ahead and apply for citizenship. In fact, we have seen so many cases that were only approved because of citizenship application. Next question, please.
Either 25 months or 29. So 25 to 29 is the current.
Okay, current processing time, I was told, is between 25 to 29 months.
So just over 2 years.
Yeah, but this one is saying after interview.
Yeah.
Normally, after interview, it shouldn't take more than 60 days after interview. But again, 751 is known to be very notorious. So the only solution is if it's been pending for so long and you're already eligible for citizenship, go ahead and apply for citizenship. Next question. Good day, sir. God bless you for all you do. If a lawful permanent resident had a family violence case dismissed, can the person travel outside the United States? Yes, you can travel, but I will take the dismissal judgment with me 24/7 because the moment they see the arrest is probably going to flag you. Then if they take you through secondary inspection, you just bring it out that yes, that case was dismissed and you show them the proof. That would be all. Next question. Is it the one that says hello, sir? Okay.
Yes.
Okay. Hello, sir. Can someone with a pending EB4 category I-485 file for employment benefit? unemployment benefit in a situation of job loss. I will not do it because that will make your green card denied, because if you are not yet a permanent resident and you are applying for unemployment, that means that the religious organization that petition for you is not paying you, which will be a disqualification. So that will deny you or deprive you of the green card. Applying for unemployment will be a ground for denial of your green card. So that will be a no-no.
And if it's EB4 and there was a job loss, doesn't that also disqualify them already?
It's employment based.
Well, it may disqualify them, but since the I-485 is already pending, if USCIS is not aware of the job loss, you may still get your green card. But if you go ahead and apply for unemployment, you are giving them official notification of your job loss. So it's going to lead to the denial of the green card. Okay, next question. Thanks, Doc. I came to the States via K1 visa and I have 2 kids back home with my ex-wife. The 2 kids were included in the I-129F petition that was approved. Please, what's the K2 process to bring in the kids? You should have processed the K2 together with the K1 once you are approved. You can't go back to the K2 because K1 visa is only valid for 90 days. If you are already here, it cannot be valid for more than 90 days. You have to be married, and then your spouse can file a petition for you and then file the petition for your children and bring them in as a permanent resident rather than as a K2. The K2 should have been processed together with the K1. So K1 visa, fiancé visa is only valid for 90 days. The visa itself, the approval is valid for 90 days. The visa itself is valid for 90 days. Upon entry, you have 90 days to get married. So everything is 90 days period. So if the 90 days already expire, you can't even start thinking about K2. It's not possible. So just go ahead, get married, let your spouse file a petition for you, and then file a petition for the children. Next question.
You didn't finish reading.
Oh, okay. Oh, I didn't know there was a part 2. Is there an expiring date for the K1? I already answered that. Approval that covers them? No. If yes, what can I do? Because I can have the kids with me until after. Is there a continuation?
High school.
Okay, until after. I don't understand. Is he saying that the children are here? No, if they are not here, that's not possible.
The children can only join after high school.
Oh, okay. Yeah, I've already preferred solution. Go ahead and get married. Let your spouse file I-130 for you and also file I-130 for the children.
No, they don't want that. Green card only for the fiance.
Yeah, that's for him. For the children, they have to file I-130 because they are still outside the country. Yes. So the spouse should file I-130 for the children. But for you that is already here on K1, you have to be married within 90 days because, like I said, that visa is only valid for 90 days. If you don't get married within 90 days, it will be invalidated. Next question. Hello, sir. On Form 864, will this be counted as 2 people or 3 people on each parent form? Single child filing for parents separately. I don't understand the question.
So the household size he's trying to determine it. Can you help me with this?
It's trying to determine household size. Okay.
So he's filing for
Will this be counted as 2 people or 3 on each parent form? Single child filing for parents separately.
It will be 2.
It will be 2. You yourself sponsoring if you are filing for both of them, on one application it will be 2. On the second application it will be 3.
Remember, they only count until they become permanent residents.
Yes, but there's a question that have you sponsored another person, so you have to answer that truthfully too. So on the first person, there will be 2. On the second person, it will be
Three.
it will be 3 on the second person. Yeah, it will be 3. Next question, please. Good afternoon, doctor. Thank you for the guidance. You are right. USCIS has a soft heart for teachers. Finally got my EAD. Now waiting for the card. You think it won't take long? This must be a follow-up question.
They had
Maybe, yeah.
comment, or they had sent in a question like a week or two ago.
Okay. Well, thank God that
That they approved.
yes. Hopefully, it will not take long. Can you please go to the next question? Good day, sir. Thank you for all you do, sir. Could you please tell me the time frame between the master hearing, individual hearing, and the appeal? Well, that's not something that we can determine. Master hearing, thousands of factors can affect it. It's not individual hearing. Those are not the kind of question I can answer. These are things that are entirely at the discretion of the immigration judge. I mean, I've seen immigration judge reschedule master hearing for 2 years, and I've seen immigration judges reschedule master hearing for 2 weeks. I've seen immigration judges who did not even conduct master hearing before going straight to individual hearing. They will just send a scheduling order and ask you and set individual hearing. So that's not something we can project. A lot depends on the judge. A lot depends on the lawyer representing you and the government lawyer. All these 3 people, they determine who to.
And it depends on the type of case, and an appeal is only necessary if the case is denied.
You know them all? Do answer.
I think it's 3,500. 35. Okay, next question, please. Good day, sir. Thank you for all you are doing for our immigrant community. Please, I'm still waiting for your response after you review my RFE and NTA case that Marisa will get to me. I've sent email. Can you please look at the name and then respond to the person privately? Look at the name. Note it and respond after the podcast.
You done?
I found it.
Yeah. Let's go to the next question. I have very limited time. It's already 12:39. I'm trying to cover as much ground as possible. Next question.
Do you have the invoice?
Let this person wait, please. I mean, this is live program. I can't be interrupting live program to attend to somebody. What's the next question? Next question.
It's there, Mr. Olu.
Okay. I'm on a J1 teacher from Nigeria, but the 212E rule is not applicable on my visa. Do I still need a waiver to change my status? Well, if it is not applicable, you don't need it, but you have to be sure that it's not applicable. That's not something I can determine. Usually, 2-year foreign residency that is not applicable, they will write it on the visa that it is not applicable. So look at your visa. If it is written there that it is not applicable, then I will take your word that it's not applicable. Next question, please. Good afternoon, Dr. Olu. Please, as the USCI started the new policy or work authorization, I'm asking about the 6 month and the new price. What is the 6 month? I don't understand this question. The new policy on work authorization.
No, I don't.
about
The
the 6 months.
price that changed.
What is the 6 months?
I don't know. Maybe they mean the extension. I don't know.
He said, have they started the new policy
I know.
or work authorization? I really don't understand the question.
There is. I mean, they increased the price, but that was back in April of last year. So
Yeah, I don't understand the question. I mean, I know that since last year, people have been paying for employment authorization. And if you already have an employment authorization that is expired and you apply for a new one before expiration, then you are entitled to the automatic extension. But that's not 6 months. That's 540 days.
oh, you're right. It is. You're right.
That's 540 days extension. So I really don't know what this question is referring to. Next question. Good day, sir. Thank you for all that you do, and God continue to prosper you. Amen. What qualifications and course can a person seeking EB2 visa have to be qualified? Oh, E2B, if EB2 is not specific to any specific qualification. Somebody who is in the sciences, education, arts, and even business can qualify for EB2. So it's not about the qualification. It's about what are you bringing to the table. It is what you are bringing to the table that will allow them or that will give them a reason to waive the requirement of job offer and labor certification. That is the requirement. It's not about what you study. Next question, please. Good afternoon, doctor. My brother lost his green card. He already requested for another new card. He filed I-90 already, but he won 2 different criminal cases. Please, can he be able to get in? No, I don't get in as how.
I think I don't know. He said he won criminal cases.
He won
so-
2 criminal cases.
Okay, so he
So
does not
I
have a criminal
posted
record.
another one, and I think it was sent via text. Let me see if this is. It sounds like the same I posted. 1 second.
Yeah, maybe if you say a clear one, because I really don't understand the question.
Yes, this is it. The one that you see.
Okay. Hello, doctor. Thank you for all you do for us. My brother lost his green card, but already requested for replacement by filing I-90. He won 2 different criminal court cases after multiple unlawful arrests. Please, can he be able to get his replacement card back? Oh yes, if he has won the criminal case, yeah, he will get his card back. Yes. Yes, so he just need to, when he filed the I-90, he will need to include the decision. Well, for immigration purpose, when it comes to criminal issues, you have to submit 3 things. You have to submit police incident report. Police incident report is different from police report. Police incident report, charges, and then the final decision. So those 3 things he should submit along with his I-90. But if the I-90 is already pending, he can go back and upload it if it was filed electronically. But if it was filed in paper form, he should attach a copy of the receipt notice of the I-90 and mail in those 3 things so that the adjudicating officer will be able to see it and then take a proper decision. Next question, please. Okay. Good evening, Dr. Asekun. Thank you, sir, for being there for us. God Almighty will continue to increase your knowledge and know-how. Amen. Quick question, sir. My spouse, a U.S. citizen, income is not sufficient. A family friend volunteered to co-sponsor. The question is, did the person need to file a separate form I-864? Yes. The joint sponsor will have to file a separate I-864. Your spouse will file a separate I-864. The one that your spouse will file, she will indicate, I am the sponsor, I'm the petitioner. The one that the joint sponsor will file, she will mark the portion that says I'm the joint sponsor. Yes, both of them will need to file IA-64. They will need to attach evidence of their income tax return. They will need to attach W-2, and they will need to attach recent payslip. For your joint sponsor, they will also need to attach evidence of citizenship. If you are applying from inside the US, 1 year tax return will be sufficient. That will be 2024 tax return. But if this is consular processing, if you are applying from outside, then you will need 3 years tax return from each of them, both the petitioner and the sponsor. Next question, please. Hello, sir. I filed for my I-485 EB2 Nigerian, wife still in Nigeria. If someone joins military, will it make the process faster for my spouse? If I plan to move her to country with current date, at this period, this thanks as you revert.
If I plan to move her.
Oh, okay, that's a different one. Okay, if I plan to move her to country with current date, should I wait till she reaches the place before applying for I-824? Well, this person says I've filed I-485. So the person is not even a permanent resident yet. So you can't even join the military until you become a permanent resident. So all these are probably asking ahead of time. You cannot join the US military until you become a permanent resident. So you will have to become a permanent resident first. So once you become a permanent resident, if your wife has already been included in your I-485 package, then you file I-824. So at that time, if you are already, well, you can't join the military until you become a permanent resident. So that's the unfortunate situation. So you have to first become a permanent resident. You can file the I-824 immediately, because if you decide to join the military first, the process of getting into the military may take several months. I really don't know the full process because I'm not a military person, but I do know that some people, between the time you submit your application and the time they will do their background check, because they will do a lot of background check, FBI will get involved before they admit you into the military. So that may take some months. So, and all these months you are waiting, the IA-24 may have been approved if you file it. So my recommendation would be, get your own green card. As soon as you get it, the same day you get it, you can file your I-824. Leave it in the country where your wife is right now. If you subsequently apply to the military and you join the military, they can always move your wife's case from one country to another. So if your I-824 is approved, they will only forward your file to the National Visa Center. So even at that, at any time after your file has been with the National Visa Center, you can still change the processing country. So if they were processing it previously in one country, you can notify the National Visa Center that you want the case to be transferred to a different country. And of course, if you join the military have they have a kind of liaison assistant, so they will definitely help you to get your wife relocated here. That is one of the things I was going to talk about on the I-130 being filed at the embassy, but I will discuss that extensively, hopefully, at the next podcast, because it's a new policy that we need to explain who is eligible, because it is not everybody, so that some people will not go and file it and then get denied at the last minute. Anyway, under the policy, they will not even take it if you are not eligible. And if they deny it, you cannot even file an appeal. We'll go into that at the next podcast. Next question.
It's 12:50.
Yeah, maybe another 5 minutes. I don't know if that court is very, very punctual. I'm not sure. Anyway, I won't risk it. I will spend another 5 minutes and leave. Good morning, doctor. The Lord is your strength. Most of your followers are all praying for you going forward. Amen. Thank you. Please, sir, I'm pending asylum, but it is advisable. Is it advisable for me to apply for EB2 at this period. Thanks as you revert. Okay, this person didn't indicate whether the asylum was filed before the expiration of the I-94. If it was filed before the expiration of the I-94, yes, you can give EB2 a trial. There's no harm in doing that. But if your asylum was filed within 1 year, but after the expiration of your I-94, you will not be eligible for adjustment. So even if EB2 is approved, you will still not be able to get green card through EB2. Next question, please.
Someone sent a follow-up question, and it brings up an important point about the payment of the I-485 if you're in court right now. Remember what we talked about yesterday?
Well,
That's this
Oh,
lady.
what I'm going to
It's
do.
the first question.
okay, sorry.
No, I'm going to skip that. In 5 minutes' time, I'm going to step out. You come in and answer questions on fees. Those are things that you can handle. So let me just answer as many as I can right now. Where are we?
That one.
Okay, this is question about fees.
No.
Okay. Good day, sir. Question for a friend. She has an asylum case pending with IJ and now based on I-140. She is trying to do the adjustment of status with IJ. She applied for asylum before I-94 expired, so she was in status. Okay, what's the follow-up? If adjust of status with IJ is possible, what will be the steps to take and what will be the timeline? Please let me know every possible steps if this can be done. Oh yes, it can be done if you have an approved. Oh, go back to the question. Did he say he has an approved or you want to apply? I didn't get that. Is that an approved petition? She has an asylum case pen and now based on I-140, she's trying to do AOS with IJ. But she didn't say whether the I-140 was already approved. Okay. I just want to be sure that I didn't miss the fact. So, this question is not complete. You didn't indicate whether you already have an approved I-140. So, if all you want to know is what to do if you believe you are eligible for employment-based I-140, the first step is to file the I-140, standalone I-140, because your friend is in removal proceedings, so he's not eligible to file concurrently with USCIS. USCIS will not have the jurisdiction over it. So file a standalone I-140. So provide the evidence of the I-140, if depending on what category, because it's the same I-140 that you use for EB1, EB2, EB3, EB1, EB2, and EB3. It is I-140 you use for those three. So if it is any of those ones, go ahead and file the I-140 and the supporting documents. Wait for it to be approved. Once it is approved, file the I-485 with USCIS in order to get receipt notice. Once you get the receipt notice, go ahead and file it with the court. File the I-485 with the court with a copy of the approved I-140.
Yeah, she's saying it's approved.
Okay, yeah. Okay, so if it's already approved, then what you need to do, file the I-485 with USCIS in order to get receipt notice. Once you have your receipt notice, go to court and file the I-485 in court. Attach a copy of the receipt notice and attach a copy of the approved I-140. So file it in court as an additional relief before the immigration judge. It is possible that the government may tell you that your friend is not eligible for adjustment based on the fact that he's been out of status. That is a possibility. But of course, if you have a lawyer, let your lawyer know that he is eligible. You may need to write a brief on eligibility. So you can go back to watch my podcast on lawful status versus lawful presence. So for somebody to be eligible for adjustment of status, they are required to be lawfully present in the United States. So if you file your asylum before the expiration of your I-94 and your asylum is still pending, you are lawfully present in the United States. So that's something that you will need. It's an argument you will need to make in court with your lawyer if you have one.
Okay, it's 56.
Okay, so you go ahead with
I'll do a
the
follow-up with that.
with the questions on the fees, and if you can also take the, I'm not sure if you can take the I-130 filing with the embassy. If you can, please do. If not, I will continue next time.
Okay. Okay. Oh, your phone. Okay. Hello and good afternoon. Okay, so the person who sent the last question sent a follow-up question. On the adjustment of status with the immigration court, is there additional charges if we need to do adjustment of status with immigration court? I was told that there is an addition US dollar 1500 along with the 1440 for the I-485. So this is true. According to the USCIS website, there are now new fees for anybody filing pretty much anything with the immigration court. There is a new list of fees. I can include the link in the description to this podcast so that you can see the full list of all of the fees that are now included. But specifically for the I-485, yes, there needs to be the 1,440, and then in addition to that, you need to pay 1,500 for the court. It's tricky because that's a lot of money just for an I-485, especially considering the immigration judge and the immigration court, they're the ones with the jurisdiction. So USCIS is really only processing the payment receipt. And specifically when you are in court, everything, the adjustment of status, any adjustment of status needs to be filed at a specific location. So it is at the Texas Service Center. That is where you will send the copy of the application along with the instructions, and if you have an attorney, a G28, and then also the fees. And from what I've read, it needs to be in two separate payments. Like it can't all be on one check or one credit card payment. It has to be two separate ones. And then you will get the receipt notices for that. Once you have those receipt notices, that's when you can file the adjustment of status with the court, which is what Dr. Asekun was saying a few minutes ago. So, yes, unfortunately, those are the new fees. Now, for anybody that's watching and say, for instance, you're filing a VAWA case, so an adjustment of status that's based on VAWA. When you are applying for adjustment of status based on VAWA with USCIS, there is no filing fee. However, now there is a fee with the court. So instead of paying the 1,440 plus the 1,500, you will still have to pay, you'll have to pay the 1,500. This is all new. This just came into effect based on the One Big Beautiful Bill Act. It was announced on, I believe it was late July. It was middle to late July that everything was announced, and we're still trying to figure out the specifics of absolutely everything because it is so new. But from what we've seen, yes, you do have to pay that additional fee. So this also, anybody who's filing, say, Form EOIR 42B, which is the cancellation of removal, that now also comes with an increased fee. Now, it used to be $100 for the filing fee and then $30 for the biometric fee. However, now there is a $1,600 filing fee and then the $30 biometrics fee, which is just an insane increase. And similarly, motions to reopen with the immigration court, they used to be $110, and now I believe they're 900. I would need to double check. Like I said, I'll go ahead and link that list of fees to this video. I'll put it in the description of this video so that you can, see for yourself all of the new fees that have to do with the immigration court. So that is the new update on the fees. And I know that the lawyer wanted me to go over this new I-130, the consular filings. However, I am going to go ahead and leave that up to him because this is something that I don't typically handle when it comes to immigration court. I handle a lot of immigration court cases. Now, personally, I am not typically the one that handles consular processing. So I would like to leave this to him because I don't know all of the everything about this. So I'm going to leave that for him for the next podcast. So let me see. Yeah, I'm going to go ahead and leave this for him to go over during the next podcast. So it is already past 1 o'clock. Dr. Asekun did go ahead and go into his hearing. So I believe that we will be rounding up today. I apologize for everyone that did not get their questions answered. I know that we've had to cut it short the last couple of weeks because we keep getting scheduled for court at 1 p.m. So unfortunately, it has been cut short. And there was one announcement that we wanted to make. So we have been getting a lot of questions to the law office cell phone number, the one that's right there, there we go, right there. So a lot of people send in their questions. First, I would like to say that this phone is really just used for the podcast. I know a lot of people try and contact like our office through this phone number, but it's really just used for the podcast. So for people to send questions. Hmm?
Yeah, we do not
Yeah,
monitor
we
it during
don't
the week.
monitor it during the week. So it stays in here. So I don't want people to get discouraged to call that phone number trying to reach us at the office because this is really only monitored for questions for the podcast, for us to repost questions. It's something, that we started doing for people to send us questions. However, a lot of people have been, joining us in the live chat. And we would like to shift more towards the live chat. That really is the best way to get your questions answered, is to go ahead and log in early and then post your questions because, obviously we go by the order in which they're posted. So if you really want your questions answered, I really recommend going ahead and logging in early and then going and posting your questions in the live chat. So if you wanted to book a consultation with the attorney, I have also posted a pinned comment at the top of the live chat that has our website where you can go ahead and book an appointment. And I will also put that in the description of this podcast as well. I believe it's already there, but I'll double check. So that will be it for today. Thank you so much for tuning in. Make sure to follow us on all the social medias: Instagram, TikTok, YouTube, X, Facebook. So please go ahead and make sure that you're following us. I have taken a screenshot of all of the questions that were not answered. So we will go ahead and answer those hopefully, at the beginning of the next podcast. So make sure that you tune in. All right. Thank you so much for tuning in. Have a great day and stay out of trouble.